hello everyone, welcome to this series where we are discussing the important articles of Indian Constitution. Till now we have discussed Article 1 to Article 11. Today we are going to discuss about Article 12 of Indian Constitution. As you all must be knowing, Article 12 to Article 35, they belong to Part 3 of Indian Constitution. Part 3 which deals with the chapter of fundamental rights. So, we will be discussing in this video about Article 12. So, you see fundamental rights, they are very fundamental in the sense that these rights, without these rights, the citizens will not be able to realize their true potential, and hence they have been kept under a separate chapter in the Constitution of India, and they have been given very high degree of protection as well, that state shall not violate these rights of citizens of this country, right? And hence it is very essential to first define what is state, who shall not violate the rights of citizens which are protected under chapter 3 or part 3 of Constitution of India. So, Article 12 gives you definition of state, right? So, let me read out the definition of state as given under Article 12. So, it says in this part, unless the context otherwise requires, the state includes the government and parliament of India and the government and legislature of each state and all local or other authorities within the territory of India or under the control of government of India. So, basically state under Article 12 has four kind of entities. One is at central level, the legislature, that is parliament, and the government at central level. At state level also, state legislature and the government at state level. Then all the local authorities, right? So, whatever local authorities we have, be it under panchayats or municipalities, all of them will also be coming under the definition of state under Article 12. And lastly, they also talk about other authorities, right? Now, these three are very easy and simple to understand. Parliament at central level, government at central level, state legislature at state level, government at state level, then at local level also. But what is the meaning of other authorities, that has been interpreted by Supreme Court in various of its judgment. A very broad definition has been given by Supreme Court of other authorities in a very famous case, namely R.D. Shetty versus Airport Authority of India case. Here Justice P.N. Bhagwati has given a 5-point test to determine whether a public authority comes under the definition of state or not. So, the 5-point test first says, the first point is ownership and financial control, meaning if in that particular authority, in that particular body, if a significant ownership is of any of the government, be it central government or state government or local government, then such a body shall be considered as or shall be included in the definition of state under Article 12. The second test is deep and pervasive control test, meaning if in the decision making of such an authority the state has a significant role to play, then also you will be considering such an authority as under the definition of state under Article 12. Then the third test is public function test. If that authority is performing some public function, right? For example, maintaining law and order, it is the role of police or it is a public function. Even if a private body performs a similar kind of function, that is of maintaining law and order, then in such a case that private body can also be considered as part of state. Then the fourth test which has been given by the Supreme Court judge is monopoly or state conferred status test, meaning if a particular authority, particular body is enjoying monopoly, especially when this monopoly has been conferred on that body by the state only, then such a body shall be considered as part of state. So, you can take example of any of the regulator, let us say RBI, right. So, banks can only be regulated by RBI and not by any other authority. What I am trying to say here is the monopoly over regulation over banks has been given to RBI by state. Without state, RBI would not have been able to regulate the banks, and only RBI can do it, meaning monopoly has been given to RBI, right? And hence RBI shall be considered as part of state under Article 12. And lastly, if state has a role in establishment and functioning of that particular authority. So there are so many bodies which have been created by a law passed by either parliament or state legislature, because in the establishment of that body, the parliament has played a role, the state legislature has played a role. Such a body shall also be considered as the part of state under Article 12. So to take an example, LIC, LIC shall be considered as part of state, reason being LIC has been created by a law passed by parliament. So I hope the definition given by Supreme Court in R.D. Shetty versus Airport Authority of India case is clear. Through this 5-point test, you can identify whether a body will be considered as part of a state under the definition of Article 12 or not. Now the last and very important thing, whether judiciary is part of a state under Article 12 or not. So you see, in the definition of Article 12, nowhere judiciary has been mentioned. They have mentioned parliament and central government, they have mentioned state assembly and state government, they have mentioned local bodies, they have mentioned other authorities, but not judiciary. And hence Supreme Court, when it has interpreted the definition of Article 12, the definition of state under Article 12, Supreme Court has said, you see, firstly, the judiciary word has not been very clearly mentioned, and secondly, what is the need of defining state is that state shall not violate the fundamental rights ensured to the people or citizens of this country under Part 3, right? So state shall not violate. Even if state violates, the people will be having a remedy to approach to judiciary, and the judiciary will make sure that those rights are protected. So judiciary basically is a protector of rights of citizens, not a violator, right? And hence judiciary shall not be considered as part of definition of state under Article 12. That is what Supreme Court has said, that judiciary is not part of state only for the purpose of Article 12, right? But Supreme Court in Rupa Ashok Khurra versus Ashok Khurra case 2002 has further elaborated. It has said that judiciary, when it performs judicial work, then judiciary shall not be considered as part of state. But when judiciary is performing some administrative work, then judiciary can also be considered under the definition of state in Article 12. Meaning, for example, Supreme Court has its own staff. If Supreme Court is recruiting its staff members, then Supreme Court shall also be under Article 15 and 16 shall be giving reservation, because all public bodies, they have to give reservation under Article 15 and 16. So I am saying, when Supreme Court is doing administrative work, so hiring its staff member is not a judicial work, it is an administrative work. When Supreme Court is doing its administrative work, then Supreme Court will also be coming under the definition of state. But when the courts, they are doing judicial work, then they will not be coming under the definition of state. That is what Supreme Court has observed in Rupa Ashok Khurra versus Ashok Khurra case of 2002. So I hope through this video you have understood, only for the purpose of Part 3, only for the purpose of fundamental rights of citizens of India, the definition of state is given under Article 12. What all comes under state, that is also we have discussed in detail. In the next video, we are going to discuss about Article 13 of Indian Constitution. Thank you so much for watching this video.